This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance. Welcome to the Luxembourg Fundcast. Today, we're doing a deep dive into, what's got to be one of the most high-stakes decisions for any company in Luxembourg.
Absolutely.
We're talking about escalating a commercial dispute into the criminal arena. I mean, for a business, for a fund, this isn't just another legal step, is it? It's a huge strategic move.
It really is. You could almost call it a true point of no return.
A point of no return. Wow.
Yeah. So today we're going to unpack the practical realities of filing a criminal complaint as a civil party. That's the plainte avec constitution de partie civile.
Right.
And then we'll get into the effects, sometimes really disruptive effects, of that legal doctrine, le pénal tient le civil en état.
Okay, and as we go through this, we want you, the listener, to really grasp three key things. First, how this plainte avec constitution de partie civile is like an irreversible ignition switch.
That's a great way to put it.
It forces a state investigation, but, and this is the catch, you totally give up control to an independent investigating judge.
Exactly. And the second big takeaway is how that principle, the pénal tient le civil en état, we're calling it the Great Freeze, how it can just stop parallel civil cases cold.
Right.
But, and this is fascinating, official government reports here in Luxembourg actually openly acknowledge it can be, misused strategically.
That's quite something. And the third insight?
The third one is about the money. There's a unique strategic financial edge here.
Okay.
The real possibility of getting all your legal fees back from the convicted party if you win the criminal case. That's something you almost never get in normal civil litigation.
Okay, that is a big deal. Right, ready to dive in?
Let's do it.
Okay, so let's unpack this a bit first. When we talk about a criminal complaint in Luxembourg having this much weight, what exactly are we talking about? How does a company even start this?
Well, generally, a victim in Luxembourg has sort of two main paths. The first is the straightforward one, the plainte simple, a simple complaint.
Okay.
You report the issue to the police or the public prosecutor, the procureur d'État. But under this principle called l'opportunité de poursuite.
The expediency of prosecution.
Exactly. The prosecutor has total discretion. They can investigate, or they might just say, look, not enough grounds, not enough public interest, and dismiss it. A classement sans suite.
Right, which for a company in a complex financial mess must feel like, like it could just disappear into thin air, right?
Yeah.
No guarantee of a proper look.
Precisely. It might just fizzle out.
But there's this other way. The more forceful option you mentioned that gets around that discretion, the one that does two things at once.
That's the one. That's the plainte avec constitution de partie civile, or PCPC. This isn't just, telling the authorities something happened. It's a formal legal action.
Okay, formal action.
The victim becomes a formal party, the partie civile. And by filing this, they simultaneously trigger the public prosecution, the action publiquée. They formally start their own claim for civil damages, but within the criminal case itself. Luxembourg law allows for this.
And who can do this? Any company.
Any natural person or any legal person, like a company, who can convincingly show they've suffered direct harm from a crime or a délit that's a serious offense.
So even if the public prosecutor looks at it and thinks, maybe not, the PCPC basically forces the issue. It makes them open a formal investigation. Is that its key power?
That is absolutely its defining feature. It's why it's often called a forced start mechanism.
Forced start. I like that.
Yeah. Even if the prosecutor isn't convinced, filing the PCPC compels the opening of a formal judicial investigation, an information judiciaire. And crucially, it's handled by an investigating judge, the juge d'instruction.
Ah, the investigating judge.
Yes. It completely changes the victim's role. They're not just reporting anymore. They're an active initiator, plugging directly into the state's most serious investigative powers.
So circling back to that first key insight we mentioned, the PCPC really is that irreversible ignition switch.
Exactly.
It guarantees the investigation starts, but like you said, you hand over the keys, you cede control to the state, and the judge is the one driving from then on.
The judge directs the flames, as you put it earlier.
Okay, so that ignition switch gets flipped, the investigation's rolling. It feels like we're now in a specific kind of legal drama. Who are the main characters here? How do their roles change once that PCPC is in play?
It really does set up a dynamic with three very distinct, very strictly defined roles. First up, obviously, is the victim company, now called the party civil.
Right, the initiator.
Exactly. Their first job is to lay out a really clear, coherent case. What happened? What was the crime? What was the harm suffered? But once it's going, they get actual rights as a party.
Like what?
Access to the case file, for one, and they can actually ask the investigating judge to carry out specific investigative actions.
Interesting. Okay, who's next?
Second, the public prosecutor, the procureur d'etat. Now, even though the PCPC got around their initial say-so,
Right, the discretion.
they're still absolutely central. The investigating judge has to send them the complaint for a formal opinion that's called the requisitions. The prosecutor is still there representing the state's interest, making sure the law is applied right, protecting public order.
Okay, makes sense. And the third key player. Sounds like the most important one.
Definitely the most pivotal once the PCPC is filed. That's the investigating judge, the juge d'instruction. This independent magistrate becomes essentially the master of the investigation.
Master of the investigation.
Yes. Their sworn duty is impartiality, uncover the truth, find evidence for the accusation, and against it. It's called a charge et à décharge.
So not just building the prosecution's case.
Not at all. They have to look at everything, and their powers are, well, immense, truly inquisitorial, far beyond anything in a civil case.
Like what kind of powers?
We're talking dawn raids, seizing documents, servers, computers, compelling people to testify under oath, appointing expert witnesses, even issuing arrest warrants. It's the full toolkit.
Wow. Okay, that sounds like a really strange, almost paradoxical situation for the company that filed the complaint.
Oh, so.
Well, they get access to this incredible state power, this investigative muscle. But you said they give up control. Is that the sort of Faustian bargain you mentioned?
That's a perfect description. Absolutely. You get the state's power, but you lose almost all control over where it goes.
So unlike a civil case where the company calls the shots.
Right. In civil litigation, you decide your strategy, what evidence to use, the timing. Here, the criminal investigation belongs lock, stock, and barrel to the judge.
And it might go in unexpected directions.
Completely unexpected. It could uncover things about the complainant's own business that are maybe inconvenient or even damaging. The judge can widen the scope way beyond what you initially complained about.
So that's the point of no return idea again.
It really is. Once that judicial machine is switched on, the party that flicked the switch can't just turn it off if things get uncomfortable.
And we really can't talk about this, especially in Luxembourg, without mentioning the European dimension, right? The European Public Prosecutor's Office, the EPPO, it's based there.
Yes, the EPPO, an increasingly critical factor, especially for financial matters.
How does it fit in?
Well, the EPPO, with its central office right here in Luxembourg, has exclusive power over certain crimes affecting the EU's financial interests.
Such as?
Things like EU subsidy fraud, serious cross-border VAT fraud, or money laundering linked to those kinds of crimes.
Okay.
In those specific cases, it's not the national juge d'instruction who takes charge. It's the EPPO's European delegated prosecutor, the EDP.
And they have different powers.
They effectively replace the national judge for that case. And yes, they often wield even broader powers, operating with a supranational mandate across the EU member states involved.
And for the fund industry.
Exactly. For the fund industry, where cross-border money flows are just business as usual, a complaint that looks purely domestic could very easily trigger EPPO jurisdiction. It adds another whole layer of complexity, another potential reach for the investigation.
Okay, so this criminal complaint is filed, the investigation is underway, maybe even involving the EPPO. What does this mean for any other legal fights the company might be having? How does this great freeze actually work?
Right, this takes us to that really powerful legal principle. Le pénal tient le civil en état.
The criminal holds the civil in abeyance.
Exactly. It's a core rule. It basically dictates that if you have criminal proceedings and civil proceedings happening at the same time, and they're based on the same underlying facts.
The same event, the same contract dispute, whatever it is.
Precisely. Then the civil court must suspend its case. They have to issue an order called certiorari, a statuer, basically. Pause proceedings until there's a final definitive judgment in the criminal case.
And why is that? What's the thinking behind it?
It's mainly about judicial coherence and also what lawyers call the hierarchy of proof.
Meaning?
Well, you don't want courts issuing contradictory decisions, right? Imagine a civil court saying, yes, you breached the contract, pay damages, and then later a criminal court, which has a much higher standard of proof beyond reasonable doubt, says, actually, no crime occurred. based on their same facts.
That would be messy.
Very messy. So this principle avoids that conflict. It's deeply rooted in Luxembourg's legal system, inherited directly from French law. It's a cornerstone.
And it sounds like it could be a serious strategic tool. Almost weaponized, maybe?
Oh, absolutely. Strategically, it's incredibly powerful. Think about it. A company is facing a tough, expensive civil lawsuit, maybe a big contract claim against them. If they can credibly file a PCPC alleging some kind of criminality related to that same contract.
Like fraud in the making of the contract.
Exactly. Or maybe embezzlement related to its execution. Filing that PCPC can effectively freeze the civil case, just stop it dead in its tracks.
For how long?
Potentially for years. While the criminal investigation and any subsequent trial unfolds, it completely changes the timeline, shifts the pressure. It can be a massive lever to force the other side to negotiate or settle the civil case.
It's really striking that the Luxembourg state itself actually acknowledges this potential for misuse. You don't often see governments saying, yeah, this rule can be abused.
No, it's quite unusual, and it really underlines the point. Annual reports from the Ministry of Justice for several years, running, I think, from 2014 through 2019.
Okay.
They explicitly mention the need to reform this principle. Why? To quote them, to avoid procedural abuses for dilatory purposes.
Dilatory purposes meaning just to cause delay.
Precisely. So the state itself recognizes it's being used strategically to block civil cases. This official acknowledgement really confirms it's a known high-impact, though definitely high-risk corporate tactic.
Right, so that brings us back to our second key insight. The Great Freeze, le pénal tire le civil en état, is this powerful double-edged sword.
Exactly.
It can stop a civil case you don't like, but it can also mean years of delay, maybe even for you, and its potential for strategic abuse is officially recognized. Okay, but does this freeze last forever? When does it, melt?
Good question. No, it's not indefinite. The clearest way it ends is when the criminal case finishes a final, unappealable conviction or acquittal.
Then the civil case can restart.
Yes, the civil court can pick things up again, though it will be bound by the factual findings of the criminal court. But it can also end earlier. Well, if the criminal action stops prematurely. For instance, Luxembourg's highest court, the Court of Cassation, clarified in a 2021 decision that the freeze lifts as soon as the public prosecutor decides not to prosecute issues that classement c'est suite.
Ah, okay. So if the prosecutor shuts it down early.
Right. Or, similarly, if the investigating judge issues an order refusing to investigate further, the reason for the suspension just evaporates at that point.
Are there any other exceptions?
Yes, the law itself creates some. For really urgent matters, like getting an injunction and action on cessation to stop unfair competition, the law specifically says the civil case doesn't have to wait. It flips the principle back to ensure quick action is possible.
Okay, this sounds incredibly detailed, the whole process. So if a company decides, right, this is the strategic path for us, how do they actually navigate what sounds like a procedural minefield? The paperwork, the costs, the time, what's involved practically?
It definitely requires meticulous preparation. You start by putting together a formal written dossier. This can be submitted in person or, more usually, through your lawyer.
And what has to be in that dossier?
According to the Code of Criminal Procedure and Ministry of Justice guidance, there are some absolutely essential parts, clauses you must include.
Okay, like what?
First, Clause 1, identifying the complainant. You need the company's full legal name, registered office, and crucially, you have to identify the actual person representing the company.
The director or
whoever has the legal authority.
Yeah.
And you need proof of that authority, usually a recent certified extract from the Luxembourg Business Register, the LBR.
Got it. Clause 2.
Clause 2. The generating facts, the fait générateur. This is the core story. A clear, precise, step-by-step account of what happened, the alleged criminal offense.
Okay.
Then Clause 3. The nature of the damage, nature du dommage. You have to spell out exactly how the company was harmed. Was it direct financial loss, damage to assets, quantifiable damage to reputation? Be specific.
Makes sense. You have to show you were actually harmed.
Absolutely. And finally, Clause 4, supporting documents. You need to attach all the evidence you have, contracts, invoices, board minutes, emails, audit reports, anything relevant to back up your claims.
And you get a copy back.
Yes. You get a formal, stamped copy when you file it, proving it's been officially lodged.
Okay, that's the paperwork. Now let's talk money. What are the costs involved in launching one of these?
The financial side. Always critical, right? There are basically three main cost components to think about.
Okay, first.
First is the consignation. It's a security deposit. The investigating judge orders the party civil yes the complainant to pay a sum of money into court.
Why?
It's meant to cover the court's costs if the complaint turns out to be frivolous or abusive. The judge decides the amount, usually based on the complainant's financial situation.
And what if you don't pay it?
Big consequences. Failure to pay the consignation makes the entire complaint inadmissible. It's a mandatory step. Just as an example, a French court in a similar situation set a deposit around 2,000 euros, but it can vary.
Okay, deposit first. What's next?
Second, and usually the biggest chunk, is lawyers' fees, the honoraires.
Right.
Now, Luxembourg didn't have an official regulated fee scale for lawyers. They set their fees freely,
Based on?
usually hourly rates, how complex the case is, the lawyer's reputation, their experience, maybe even the outcome. But one key point. Pure contingency fees, where the lawyer only gets paid if you win. As a percentage, those are prohibited.
But they can have success fees.
Yes, a success fee on top of a base fee is allowed and quite common. And the third element is expenses usually billed as maybe 5 to 10% of the legal fees, covering general office costs, admin, that sort of thing.
Okay, so deposit, lawyer fees, expenses. And this brings us back to that unique financial advantage you mentioned earlier, doesn't it? The potential to get those fees back.
Exactly. This is where it gets really interesting strategically.
How so?
Think about a normal civil case. If you win, the losing side usually pays the basic court cost de dépôt and maybe a small symbolic amount towards your legal fees called an indemnité de procédure. It rarely covers much of your actual lawyer bills.
Right, you still end up out of pocket for most of your legal spend.
Precisely. But in a criminal case, if you're the party civil and you succeed, meaning the defendant is convicted, you can ask the court to order the convicted party to pay your full, reasonably incurred lawyer's fees as part of the damages.
The full amount.
The full reasonable amount. There's clear case law from Luxembourg's Superior Court of Justice confirming awards that include reimbursement for honoraires d'avocat lawyers' fees running into tens of thousands of euros.
That really changes the calculation.
It fundamentally alters the risk-reward analysis. It can make pursuing a potentially very expensive criminal route seem much more justifiable financially if you have a strong case.
Okay, so that hammers home our third key takeaway. The financial calculus is truly different here.
It is.
The criminal path offers this very real chance, not guaranteed, but real, of getting your entire legal spend back from a convicted opponent.
Wrong.
A massive strategic plus that might outweigh the risks and costs. But for any business, time is money. How long does this whole process usually take? Is it quick?
Definitely not quick. You need to be clear. This is a marathon, not a sprint.
Right.
The first phase, the investigation by the juge d'instruction, that can vary a lot. A straightforward case, maybe 3 to 6 months for the investigation part.
And complex ones.
For a complex financial crime case, what they call an affaire d'envergure moyenne, official estimates say the investigation alone takes 6 to 12 months. But honestly, in practice, it's often much longer.
Years even.
Easily.
Yeah.
Highly complex international fraud cases can take several years just for the investigation phase.
And that's just the investigation.
Right. After the judge finishes investigating, the whole file goes to a special pretrial chamber, the chambre du conseil. They review everything and decide. Dismiss the case or send it for trial.
And then you get a trial date.
Eventually, yes. So realistically, from filing that initial PCPC to getting a first judgment from the trial court in a complex case, you could easily be looking at 2 to 4 years, maybe even longer.
2 to 4 years or more.
Yes, and remember, during potentially all that time, any parallel civil case based on the same facts is frozen.
Right, the great freeze.
Exactly. So that protracted timeline is a massive factor you have to build into your long-term business and legal thinking.
Okay, so given all of that, the complexity, the significant costs, these really long timelines, why on earth would a company choose this path? What are the ultimate strategic upsides that make it worthwhile?
Well, sometimes in really high-stakes commercial fights, just the credible threat of filing a criminal complaint is the ultimate leverage.
Just a threat.
Absolutely. Think about what that threat means for the other side. A formal criminal investigation, potential ruin for their reputation, personal liability for their directors, invasive searches and seizures, huge legal costs for them, too.
That's a lot of pressure.
Immense pressure. Often, just raising the realistic possibility of a PCPC can bring an opponent who was maybe completely dug in, running to the negotiating table very quickly. Experienced lawyers often see the PCPC not just as a tool to get a conviction, but as a strategic device to force a good settlement out of court.
And you mentioned the system even has ways to encourage settlement.
Yes, that's right. Luxembourg law includes a procedure called penal mediation penal.
Okay.
This allows the public prosecutor, before even deciding whether to prosecute fully, to suggest a formal mediation between the offender and the victim.
What goal?
The aims are explicit: get compensation for the victim's damages, and resolve the whole conflict without needing a full trial. It actually shows the system itself accepts and even encourages finding alternative solutions, even when crime is alleged.
Okay, so leverage and potential settlement paths. What about the unique advantages if it does proceed? You mentioned 4 core ones.
Yes, 4 key strategic advantages, kind of the unique selling points of this route. First, state-powered investigation.
We talked about the judge's powers.
Exactly. Dawn raids, seizing servers, wiretaps, overriding bank secrecy. Powers that are just unavailable in civil cases. Invaluable if you suspect fraud or hidden assets.
Okay, number 1. Number 2.
Second, access to the criminal file. Once you're formally the party civil, you and your lawyers get to see the entire investigation file.
Everything the judge gathers.
Yes. Evidence, witness statements, expert reports. It gives you incredible insight into the strength of the case, the other side's position. A massive strategic advantage whether you're heading to trial or still negotiating.
That sounds huge. Third advantage.
Third, maximum pressure on individuals. This is key. Civil cases are usually company versus company. Criminal law targets actual people.
Directors, officers.
Directors, officers, key employees of your opponent. They face personal criminal liability. We're talking potential fines, potentially prison time months, or even many years for serious financial crimes. That personal risk is a huge motivator for them to find a resolution, something absent in purely corporate civil fights.
Makes sense. And the fourth one?
Fourth, as we've already discussed, full cost recovery potential. That unique ability, if you win, to potentially get all your legal fees back from the convicted defendant. It changes the whole financial picture.
Right, so powerful investigation, access to the file, pressure on individuals, and cost recovery. That's quite a list.
It is. They collectively explain why, despite the risks and complexities, this remains a potent strategic option.
So it sounds like a pretty established, powerful legal framework. But is it static? Or is this legal landscape in Luxembourg changing, evolving?
That's a great question. It's sort of both, which is interesting.
How do you mean?
Well, the basic pillars, the PCPC itself, the role of the investigating judge, that core principle of le pénal tient le civil, these are incredibly stable. They're deeply embedded in Luxembourg's civil law tradition, which is very durable.
So the foundations aren't shifting much.
The foundations are solid. However, how these principles are applied in practice, that's constantly evolving. The landscape is definitely not static.
Can you give examples?
Sure. Look at recent legislation. There was a law passed on January 23rd, 2025, that actually introduced new procedures for hunting down fugitives, giving investigators more powers.
Okay.
And another law from July 22nd, 2022, laid out detailed rules for the investigative powers of the EPPO, the European Public Prosecutor's Office, which we talked about. That's quite new.
So the rules are being updated.
Constantly.
Yeah.
And there are ongoing legislative projets de loi in the pipeline right now. Things like more digitalization of court procedures, adapting rules for specific types of crime. It keeps moving.
So it's this kind of duality. Stable principles, but changing practices.
Exactly. Stability in principle, but definite flux in practice. And what that means really is that just knowing the historical background isn't enough. To use this strategy effectively, you need advisors who not only get the timeless strategic trade-offs, but are also absolutely up to the minute on the latest procedural tweaks, the newest court decisions, even the draft laws being debated. It really is a specialist's game.
It certainly sounds like it. But okay, before we finish, let's just quickly recap those 3 critical takeaways from our deep dive today, just to really nail them down for everyone listening.
Good idea.
First, we established that the plainte avec constitution de partie civile is like that irreversible ignition switch. It guarantees a formal state investigation starts, but the price is ceding control. The judge directs the flames.
Couldn't say it better.
Second, the great freeze. Le pénal tient le civil en état. A powerful, double-edged sword. It can paralyze civil suits, which might be useful, but it could also mean years of delay, and its potential for strategic abuse is even noted in official government reports.
A crucial point to remember.
And third, that very distinct financial calculus. The criminal route offers the unique, very real possibility of recovering your entire legal spend if your opponent is convicted. A strategic upside that can sometimes justify the significant risks and the upfront investment.
Absolutely. Key financial difference.
This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.